We are set today on the court's docket for an adversary hearing. This case is being heard today from Lockhart, Texas.
On Alisa Longoria for the department.
Ms. Smith?
Anne Marie Smith for the mother, Miss Angela Grady. She's present on the platform. We're ready. We have mostly agreement, I guess, but there's still a couple of matters that need to be taken up.
Okay, Mr. Katmar?
Douglas Katmar for Future Shaw. Not ready, no contact. Spoke to the mother. She told me he was just arrested. She didn't know what for. And I haven't had a chance to look it up yet, Your Honor, but he's in Bexar County Jail, according to my client's mother.
And Miss Janice?
Jennifer Janice, attorney ad litem for the child, ready.
Okay, the court does note that Miss Grady, the mother in this case, is present participating by video. We also have representatives from the Department of Family and Protective Services and Belong. Ms. Longoria, do you know if you have service on Mr. Shaw in this case?
We do not have service on Mr. Shaw or Miss Grady, but as you notated, she is present in court today.
Okay, so the court will grant the not ready announcement as to Mr. Shaw. So Ms. Smith, have you had an opportunity to discuss this case with the department to see if there are any agreements that can be reached?
Yes, Judge, and we for the most part have an agreement. We don't have an agreement as to visitation, and then there's an ancillary matter that I would like to bring up with the court that's not necessarily part of the agreement. That would not fall within the scope of the agreement, Judge.
Okay, so is your client agreeable to the department being named as temporary managed conservator?
She is she's agreeable to that, with her named as a possessor conservator. She wants her aunt studied. It's a maternal aunt, and I've provided the name and telephone number to the department. We're asking for an expedited study. The reason for that is her father has a terminal illness, and stepmom is really the primary caretaker. And so as things progress in the downward slope, the caretaker also works. It's an infant who's only 2 months old, and she feels that her aunt would be probably better suited to be the caregiver. And so we're seeking an expedited home study for that aunt. Margot Tenoria, and I did provide her telephone number to the department. We're also asking for an FGC to be held, and we're asking for child support to be deferred. We are asking for, because this child is so young, we're asking for 2 hours weekly supervised by the department. The department is only agreeable to 1 hour. As the court knows, 1 hour goes by in a blink, and we are talking about a 2-month-old child. So that is where we differ. We are seeking 2 hours of supervised time with the child. And then I have another issue.
Okay, so Ms. Longoria, you'll let me know what the department's agreeable to and what your understanding of the agreed terms.
Yes, Judge, we are in agreement to everything, as Ms. Smith stated, except that visitation. TMC to the department, we are agreeable to that expedited home study. We are agreeable to the deferred child support. However, we are only agreeable to 1 hour weekly visitation. We are willing to bump that up to 2 hours weekly once she starts engaging in services. However, we do feel that 1 hour is appropriate for the time being. And we are also asking, in reference to that visitation, that the appointments be confirmed 24 hours in advance.
Okay, so Ms. Janice, this is your client, who is almost 3 months old at this point.
Yes.
You have a position on visitation or any of the other terms?
Judge, I don't mind visits being 2 hours. I agree with Ms. Smith that the child is very young. So that would probably help with bonding. As far as the home study on the aunt is concerned, I'm happy with current placement. Ms. Smith is correct that grandfather does have a terminal illness, but at this point, step-grandmother is reporting that she's able to handle it. She seems on top of things. And so I would not be in support of a move right now, although I don't think it would hurt to have a backup home study done just in case things change.
And Judge, the mother's preference is that the child is placed with her aunt, who is also within the 3rd degree of consanguinity.
Ms. Janice, can you tell me about the current placement for Bishop? Is it a foster home, a fictive kin? What is it?
It's her father, it's mother, it's maternal grandfather, and then his wife, so step-grandmother.
And so, Judge, if something happens to her dad, which she feels is imminent, she wants the child with her relative, with a blood relative, and not a step somebody.
And Judge, I will add that mother was, it's my understanding, was already living in the home for a time period with baby and her parents. And so they have had previous contact with them, and he's been there up until he was removed recently and then put back by the department.
Yeah, Ms. Smith, your client doesn't currently reside in that home, does she?
She does not.
Okay. Okay, so the court's going to enter the following orders today. First, court does accept the agreements of the parties as to naming the Texas Department of Family and Protective Services as the temporary managed conservator of the child subject to this suit, Bishop. The mother, in this case, Ms. Grady, is named as a temporary possessory conservator. The court will order an expedited home study on the maternal aunt. Her first name was Margot, and I'm sure I did not.
Tenoria.
Can you spell that for me again, Ms. Smith?
Yes, Judge. It's T as in Tom, Enoria.
Okay, thank you. So expedited home study on her. Court does order a family group conference be held in this case. Any child support is deferred to our status hearing. The court will continue the current placement with the maternal grandfather and the step-grandmother. There can be a change in placement by agreement of the child advocates. We are going to come back for status hearing on May 28th at 3:30. Again, May 28th at 3:30.
And Judge, there's one more issue.
All right, well, I'm not done yet.
Okay.
And then as to visitation, the court will, because this child is 2 months old, the court will order 2 hours weekly supervised visitation. Okay, Ms. Smith, what is your other issue?
So, Judge, my other issue is I feel that the affidavit did go into some violations of HIPAA. The affidavit basically was written or filed on April 1st. And the department was given emergency orders, I believe, on also April 1st. The information that was gathered back on January 1st, well before the department was named anything. They referenced in the affidavit some protected health information as to the child, and I get that maybe it was a concern. I don't know why it would even be a concern. But in any case, there was some referenced health information that is protected under HIPAA. They backdoor got it in by referencing what they spoke to somebody from the hospital who told them XYZ about the child. The mother was never contacted as to whether or not she agreed that that information could have been made public. My issue with it, Judge, you know, if we had had a hearing and they talked about it and it came out, there's not much I could do about it, but this is a record that is going to be filed. This affidavit, actually, it has already been filed. It has very significant protected health information that the only way this would be attributed to the child is because it was attributed to the mother. And I feel that it's a gross HIPAA violation. I sent the department and all the parties an email asking them to rescind it, and that I would be happy to file an order for the, asking the district clerk to seal that record, that affidavit, and they refile another affidavit, and they can put in the affidavit, confidential health information or whatever, however they want to characterize it. I was told that somehow it had some significance to the hearing or to the information or to the concerns, which I really don't see how, but I feel like, sanctions are probably going to be asked for if they don't, if this is not rescinded. It is a gross HIPAA violation, Judge, and I am asking that the court orders the department to rescind, refile their affidavit and taking out any HIPAA information. And we circulate an order that basically directs the district clerk to seal the initial affidavit so that information is not there. That could be readily made available to the public. And I don't think that is.
And Ms. Smith, our files are non-public. I mean, you can't walk in and get.
I understand, but it's available to, you can file, people file for things all the time, Judge. The fact that it was made public to this platform is a problem.
Okay, let me tell you what, I'm gonna start a breakout room. If I see the attorneys in chambers, let's discuss it off the
Yes,
record.
Judge.
Okay. The attorneys and I will be back here in a minute.
Your Honor, can I be excused?
Yes, sir, Mr. Katmar.
Thank you so much.
Okay, so the attorneys and I are back from the breakout room for our in-chambers discussion. I think everything at this point is worked out or well on its way to being worked out. So again, at this time, the court does name the Texas Department of Family and Protective Services as the temporary managing conservator of the child, the subject of the suit. The mother is named as a temporary possessor conservator. The court has ordered 2 hours of weekly supervised visitation for the mother. An expedited home study has been ordered on the maternal aunt, Margot, and y'all had a spelling for her last name. The court also orders a family group conference. Let's see, we need to take care of ICWA. Let's see.
Oh, there is no ICWA, Your Honor. I'm sorry. My client denied ICWA.
Okay, so court will find that on the mother's side of the family, Ms. Grady's side of the family, there is no Indian child heritage. So that finding can be included in the temporary order. Let's see. Ms. Grady, this is Joe Stuckey speaking. I do have to warn and admonish you in each of these hearings that your parental rights are still subject to further restriction or even termination unless you're willing and able to provide Bishop with a safe, stable, drug-free, violence-free environment. Do you understand that warning, ma'am?
Yes, sir.
Okay. Stay in contact with your attorney, Ms. Smith, as well as your new caseworker that'll be assigned shortly. And
Okay.
we'll see everyone back on May 28th at 3:30.
Thanks, Your Honor.
Okay. Thank you, everybody. You may be excused.
Thanks.
Thank you, Judge.